Hello once again, I'm Chief Judge Dan Greear, and thanks for joining us again with Understanding the ICA, our effort to help everyone, lawyers and non-lawyers alike, understand the inner workings of the new court. Today we're going to talk about oral arguments. Once your appeal is filed and each party has had the opportunity to submit a written brief arguing its position, the ICA judges, with the help of our law clerks, review the briefs and record that you and the other side provide to us. Once we have an understanding of your case, we meet and decide whether the briefs provide enough information for us to make a decision or whether we need to hear more from you in the form of oral argument. If the ICA has voted to grant oral argument in your case, you will receive a notice of argument from the clerk's office. This form asks that you select whether you'd like to have your argument be in person at the main courtroom in Charleston, or if you'd like to request argument at one of the court's 5 remote locations. Whether your argument ultimately is in person in Charleston or remote, you can expect an equal opportunity to be heard. Another video will discuss the court's 5 remote locations, including the video technology that will be used in more detail. There are 2 types of oral argument at the Intermediate Court of Appeals. If your case is set for the Rule 20 docket, that means it is a case involving issues the ICA and the Supreme Court haven't already considered. A case of fundamental public importance, a constitutional question about the validity of a law, or a case involving an issue that other courts around the state have disagreed on. If your case is set for the Rule 19 docket, it likely involves more settled law and that the issues deal with how the lower court applied that law or weighed the evidence. Oral arguments at the ICA operate like those at the Supreme Court of Appeals. The ICA follows the same time frame guidelines and limits for argument as the Supreme Court. That means each side will have roughly 10 minutes to make an argument in a Rule 19 case and about 20 minutes in a Rule 20 case. Just like at the Supreme Court, the Chief Judge will run oral argument by monitoring the time given to each side, and the Chief Judge can shorten or extend the time depending on what helps the judges understand the arguments. You come to oral argument with your argument prepared. While you should be ready to argue your case as prepared, the judges will probably ask you some questions as you make your case. So you should understand the facts and law well enough to respond to questions that may relate to different issues that you had not planned to focus on. If you want to learn more about the specifics of oral argument, you should review Rules 19 and 20 of the Rules of Appellate Procedure, which are available on the West Virginia Judiciary website. Thank you once again for watching, and I look forward to speaking with you again soon.